walking after lunch into a really exciting panel, which is on looking at the National Tribunal Commission's work and figuring out how to make it work. This is a rich panel. We have a great profile of people. And in starting from the person who is going to be moderating the panel, which is Dr. Krishnan, who is faculty at NCAER. As with all the panels in this conference, we start with a presentation. In this case, Surya from DAKSH should be making the presentation. And then it's about for 15 minutes, I guess. That's it. And then Krishnan, you will take over in terms of this panel session. Surya is going to start his presentation. You can ask Bairam to poke him if he goes beyond 15 minutes, and then the rest of the panel is up to you. So Krishnan, all yours.
Hello, good afternoon. I'm Surya Prakash from DAKSH. Thank you, Ajay, Susan, Pavitra, everybody else at NCAER. Great event. And for the opportunity to present about NTC. It is an idea that has time is always in the future. It's always been talked about, but has never really happened. So in this presentation, we share some parts of the paper that we wrote about 6 months back on what NTC, how the idea of NTC came about. It's a short presentation. Talk about how the idea of NTC came about. What would it mean for NTC to be there? What all can it potentially do? But maybe we're getting ahead of ourselves. Is NTC even possible, feasible? And if yes, in the scope of reality, what should it do? That's what we try to cover in this paper. It is not database, based on reading of judgments and other policy papers. Tribunalization in India, although some do still have reservations on effectiveness of tribunals, they are here. They have been there for some time. The Income Tax Appellate Tribunal being the first such tribunal in India, it's been more than 75 years. And post 1980s, there's been an explosion of such tribunals, and it seems to be that the jurisprudence on the constitutionality of tribunals are well settled. Their effectiveness and how good they have worked to meet their objectives of faster disposal, enabling access to justice, etc., not widely studied, and that's possibly something that we will come to in just a bit. So again, this is not a flow. This is just a stock figure. As at certain date, these were the cases pending in various tribunals. This just to give a sense of which are the big ones and why it is important to engage with. While a lot of the discussion is on National Company Law Tribunal and maybe NGT, the other run-of-the-mill cases that are handled by ITAT, CESTAT, and CAT don't seem to get a lot of attention. This slide shows the vacancy across tribunals. This is again important because the vacancy is what led to the conceptualization of NTC. Again, as you can see, it's fairly high in NCLT and ITAT. Like I said, this is a paper that we put out in April 2021, co-authored by Akanksha, who's going to join us or maybe just joined us, Siddharth and myself from DAKSH. In this, from now on, we talk about why the NTC idea came about very briefly. These are the problems that are identified in the judgments and some policy papers. There has been no quantitative engagement with identifying problems of the tribunals. So we have based this on what have been cited in the judgments and other such policy papers. There is talk of executive interference. Again, just to nuance it, it may vary, the problems may vary, and the extent may vary between tribunals. So there is executive interference, there is some talk of narrowness of perspectives of judges because being too technical and not looking at the common law as a whole. But there's also the dependence on the executive for resources, infrastructure, premises, and a lack of an over tribalization. Every time there's a new area of law, just create a tribunal for it. RERA has come up. Just last week there was talk of a motor vehicles accident claims appellate tribunal. So every time there is a problem, create a tribunal. There are also procedural inconsistencies between tribunals, which is you could say by design, because all of them have come up through different ministries, have grown out, growth from different ministries' procedures. So there is a non-uniformity. They are outdated, like much of the court processes are, and don't lend themselves to adopting of technology. And there are pendencies and delays, and being urban-centric. The problems have remained like this for some time now in some tribunals, which is why you will see that this idea of a body to take care of tribunals has been there for some time. First mooted in Kumar in 1997. The jurisprudence on tribunals and their constitutionality just go back 10 years earlier, mid 80s, when they were first stamped with approval, and then an independent body to see the appointments of tribunals was first mooted in 1997 in Kumar, and then it has continually the last 10 years gained more acceptance within the Supreme Court jurisprudence to say, why has it not been done? Why can't we look at it like this? Can you add this function also to it? All of those have grown repeatedly. So at least over the last 10 odd years, there seems to be a lot of reference to the need for a body separate from the tribunals to manage the appointment process, administration, and other resource constraints of tribunals. Very quickly, recent developments over the last 6 months, there was a clash between the union government and the Supreme Court on whether an ordinance that was passed in blatant, where they use a non-obstante clause and said, notwithstanding anything in any judgment, we will say that the term for members should not exceed 4 years. While the Supreme Court clearly had said in the Madras Bar Association case of 2020 that it should be more than 4 years. And it led to a lot of discussion on judicial independence and parliamentary powers to override judgments. But as it stands, an act has been passed in August or so, which says should not exceed 4 years. But what is NTC? What does it mean? Is something that we should go into. This is how it looks, the structure as it looks. There are parent ministries and departments who now support these tribunals, which hear disputes against those departments, many cases. And then appeals lie to them to the High Court, and in some cases to the Supreme Court. The red line, if you can see it, are the appeal routes, and the blue lines represent the departments that are responsible administratively for these tribunals. What would it look after NTC? The appeal route does not change. So judicial functioning does not change. This is only an administrative side change. So all of these tribunals, and again, we leave that as the question, at what point of time, what tribunals should be subsumed under this regime. Potentially, all tribunals can become administratively be managed by the NTC. That's how the Supreme Court judgments envisage this organization to be. In this paper, we also make a case for saying that if an NTC does come into existence, it should fit into the other institutions that are responsible in this space. For example, they should come under CIC, CVC. They should be responsible to the parliament by putting out annual reports and reporting on their budgets, and also be transparent to citizens in respect of their further zoom into what NTC would look like structurally. This particular structure of the board of NTC is from the minority judgment of Justice Chandrachud in Roger Matthew, where he says there should be a Supreme Court judge who is the chairperson, 2 chief justices, and 2 other judges, 2 secretaries, etc. So clearly, there is a preponderance of judges over the executive in this structure as envisaged in the minority judgment. There are secretariats to handle different functions, and that may be worth discussing, and we do have an open question on that. So what should the NTC do? Because the problem has arisen from the lack of timely appointments to the tribunals, NTC has been seen to be a solution for timely appointments, robust appointments. So appointments is appearing consistently across all of these discussions. There are related staff-related points and evaluation and even sometimes removal. There is administrative oversight, including process reengineering and case flow management, and infrastructure, which has appeared consistently in all judgments to say that this body should look at infrastructure problems of the tribunals. Now we throw open this discussion and say, while NTC is figuring prominently in discussions at the Supreme Court level, whether an NTC or let's call it an unified umbrella body is required at all. We believe it is required, what should its role be? Can appointments actually be supported by a body like NTC? Given that the discussions and the concerns over tribunals are coming up in the area of appointments, we believe it should handle it. It does raise a question. In fact, a lot of the discussion on NJAC is very parallel to the discussions on NTC. Who should have control over appointments? Should actually executive have an overriding power? And if an NTC is indeed required, what should its role be? Phased manner. How should it increase its scope tribunal-wise, or should it increase its role, sequence its role function-wise? So we believe that it should be sequenced out both functionally and tribunal-wise, so that there is an evidence of its viability over time. And those are the questions that we would love to get answers on.
Thank you. Thanks, Surya, for that context-setting presentation. We have close to 50 minutes, and we have 4 discussants. We have Pratik, Datta, we have Pramod, Kumar, we have Shubho, and we have Somasekhar. Pratik and Pramod, I think, are joining virtually, and Shubho and Som will be here soon, and Shubho is here. Before I come with specific questions to some of you, to very quickly summarize what Surya said, tribunals were created for supposedly technical expertise and quick remedies, largely in economic and commercial areas. In addition, they were to help reduce pendency in the overall judicial system. The constitutional challenges are by and large, I think, behind us, though I think there are footnotes in all those judgments which can now come back and sort of become serious questions again. The serious, I think, question that we need to focus on is the one that he left us with in the last slide. Have tribunals worked? By and large, I think the view would be there is no great improvement in the pre-tribunal situation compared with today. And there are clearly a number of reasons for this, some administrative, some infrastructure related, a whole bunch of reasons. Surya has touched upon them. We won't go into these at this stage, but I think the question that we want to focus on as part of this panel is NTC, the National Tribunals Commission, the composition, the board structure, etc., are second order questions. But I think first order question is NTC the panacea that it looks like? Maybe start with Mr. Pramod Kumar, since he is part of a tribunal, probably one of the oldest tribunals, the Income Tax Appellate Tribunal, a member of the ITAT. Mr. Pramod Kumar, would you like to go first and take a stab at this question? Is NTC the panacea that it looks like?
Thank you so much. I think before we go to this question, first thing we need to address is as to what is the problem which is sought to be addressed. Now, if you think of the problem and which is the root cause of NTC being talked about or this idea being conceived, there are four fundamental problems. One is about the physical and human infrastructure. That's the area where tribunals have been found to be lacking. The second is selection and timely selection of the members and chairman and vice chairman, etc., and of suitable persons. Third is ensuring functional independence. Now, when you think of functional independence, it has to be, one has to realize that it is slightly distinct from elimination of the role of executive. I mean, per se, in the role of executive, I would say I see nothing wrong. But then, and the final point is, which is the most important from my perspective, is establishing integrity and efficiency of the individual tribunals, which again has three segments. One is professionalism in those tribunals, that is capacity development area. Second is the value system, the sound value system which they built over years and decades. And third is discipline. How do we ensure discipline and how do we neutralize the impact of deviant factors? Now, these are the four things which to my mind are the basic issues which have been identified in successive judgments. Now, if you think from this perspective, and as I speak, I must make it clear, I should have done that earlier, that I speak in my personal capacity. Views are entirely my personal. This is an academic discussion, and I'm still working in the tribunal, so there are limitations to what I can say, and I hope you will appreciate that. Now, as far as the first problem is concerned, that's of the physical and human infrastructure. That is one thing which has been discussed again and again by the judgments of honorable courts above. But then you also have to realize that what has happened in last 5-6 years in the tribunals is something which is very positive. We are moving in positive direction. I can tell you about my tribunal. In the ITAT, this was one area which was neglected, but in our own government is working on it. So the question would arise, do we need NTC for playing a proactive role on this? But yes, NTC may have some role in the sense it can be institutionalized. Second is selection of member and chairman. Now, that is where there has been some discussion and debate in the judicial circle, whether the selections are timely or not, whether the quality is up to the mark or not. But then again, as I was looking at these slides, I saw Surya goes on the basis that there has to be uniform selection criteria for judicial members in all the tribunals. That itself proceeds on a fallacy, that all tribunals are the same. They are different tribunals. They have different value system. They have different work. And as Krishnan mentioned about the role of the tribunal, and they said it is, they were supposed to supplement the work of the courts. I would say that there are institutions like Income Tax Appellate Tribunal, which is final on the question of facts. And therefore, the emphasis in my tribunal, for example, is how do we ascertain those factual elements which are to be taken to the courts? We are not supplementing the work of the courts in that sense. We are, as a matter of fact, it's an independent adjudication of the factual aspects. And that's where the expertise, area-specific expertise develops. But yes, that's important. Now, when it comes to elevation, that's also part of the system. There again, ITC may have a role to play, certainly. I mean, to select the members in time, to select the chairman in time. But then, yes, that is something, should the NTC do it, or just a proactive role being played by the courts, which is being played now. That should be good enough. That's a call to be taken. Third area is functional independence. Now, functional independence is something which is more like a structure and which can also be done by way of providing sound framework of laws in which the tribunals function. How would NTC go on day-to-day basis to ensure this functional independence is something which I'm yet to understand. And I must tell you, as I said in the beginning also, that one has to appreciate the fine line of demarcation between the role of executive in day-to-day management of the tribunal vis-a-vis interference by the executive. Now, every role is not an interference. There are certain areas where executive can play a very important role. And that's what I would think must continue to play. So if somebody was to concentrate on the first principles, I would have said that have a framework of law which ensures the functional independence, and then have its oversight body not as big or as on as a kind of a scale which I see it as, which ensures that this functional independence framework is reviewed from time to time. That should be good enough. Now, fourth point and last point is, how do we improve the efficiency and integrity of the institutions? That, to my mind, is the most important part, which again is into three parts. One, as I said, there has to be professionalism in the working of each tribunal. Take ITAT, for example, Income Tax Appellate Tribunal. We have more than 81 years. We will be completing 82 years, within 4 weeks from now. 82 years of an institution. We have seen ups and downs. We have seen the sound jurisprudence, sound systems built by this. And there are people, I'm one of them who has been here for the last 22 years, this institution. This professionalism that we have in our work, I think similarly other tribunals also, that needs to be encouraged. With capacity development, there has to be we have to play a key role. And my thinking is that probably much more than any external body, this is someone who is inside the system, or someone, the top management, even with the adequate powers, they can play a much more important role than anyone outside of the system. Similarly, when it comes to value system, as I was mentioning, there has to be value system. Now, when you are going to have members who will be here just for 4 years, I do not know how much they'll be able to imbibe institutional values. But yes, NTC can have a role to play in this, but much more than that, an internal mechanism of the ITAT will also help. And finally, the last point, which is where I mentioned about the discipline. Now, discipline and neutralizing the impact of those factors which are slightly deviant from what ought to have happened in the first principles, that's where a very, very important role is to be played. To suggest that NTC can play a better role in handling this would probably be an exaggeration, in the sense, this is my personal view, that even to understand functioning of a tribunal, which is a huge subsystem within the large system of judiciary and slightly smaller subsystem of the tribunals, is quite a task. An example was just given by Surya. I saw that he mentioned about when he was mentioning about the figure of pendency, he mentioned 88,000 pendency as on some date in February. Now we have a pendency of 56,195 when I checked up just half an hour ago. On the face of it, it looks good, but you have to be inside the tribunal to understand that our institution, for some reasons of a paradigm shift in the functioning of the ITAT, is down by 80%. Somebody has to be inside the tribunal to understand that more than 20,000 appeals are withdrawn. So these figures could be misleading. If you see the disposal figure today, that would not reflect the efficiency of the tribunal or efficiency of the institution or efficiency of the members concerned. So these are the such localized factors that I would think that NTC, so far as the fourth segment, which is efficiency and integrity of the system is concerned, which is the most important one, will have a limited role to play. That's my take on the role, on how the NTC could play a role in the as envisaged by the different decisions. Selection of members, maybe, and physical and human infrastructure, government is doing a brilliant job for the last 4 or 5 years. If somebody can supplement it, that's great. Ensuring functional independence, it's a call to be taken, whether you need to on a day-to-day basis or you need to do it by providing a mechanism. And on efficiency and integrity of the system, as I said, this is best handled by the NTC.
Thank you, Mr. Pramod Kumar. That is very useful. You drew our attention to the importance of understanding the different nature of tribunals just putting them all together in one category, calling them tribunals, in a sense, maybe doing injustice to the statement of the problem. Two, you said, I mean, I'm putting my words to it. Uniformity is not necessarily a virtue. Three, the executive and the judiciary need to play a role which may not necessarily get played better because you create an NTC. Interesting viewpoint. Can I now move to Shubho, who's present here, to comment on the presentation, the question that I posed, and some of the comments that you heard from Mr. Pramod Kumar. Over to you now.
Let me add something before you go to Shubho. Just on a small.
Yeah, go ahead.
The point I was making regarding the uniform selection, uniform qualifications. Now the government doesn't recognize. If you look at the act which has been passed and you look at the qualifications of judicial members, they not only need the legal experience, they need legal experience in the related field. For example, if somebody is practicing IPR and tomorrow he wants to become a member of the ITAT, by legislation he's out. So something which is out by legislation, to when you put it in the slide that you want uniform qualification, to bring it back via NTC is quite a job. That's it.
That's a useful point. Shubho, while sort of speaking on other topics, this is a question that has come up repeatedly. In the tribunals, originally there used to be a category called judicial member, the category called technical members. The theory, if I understand right, and Bairam can supplement this, there is a certain judicial temperament which is irrespective of the domain. And then there is the expertise of the domain. My understanding was the judicial was not supposed to be expertise in the area. The technical was the expertise in the area. So now by saying judicial is judicial expertise in the area, technical is technical expertise in the area, I think we are creating a whole bunch of new taxonomies. So in addition to other points, in your 10 minutes, can you attempt answers to all these questions? Thanks.
Thank you, Dr. Krishnan. On the question you asked, this is based on this, I would say, worthless task of trying to separate a legal dispute into procedural questions and questions of fact. While lawyers love to do it, once the rubber hits the road, it all becomes a jumble mess. The reason why I think we needed judicial members in tribunals is because there is no civil procedure code in the tribunal. So there is there's a vague statement called natural justice. And what natural justice means at different points in different times, when a witness is turning hostile or when the witness starts breaking down in court and starts crying, becomes a question which you get by practicing civil procedure for a long time. And if you were to just turn, instead of a 2-page or 3-page procedural rules, which is most tribunals have, if you turn them into something like 144,000 word procedural rule book of, say, administrative agency in the first word, I don't think there's any need for legal training in that. The questions of procedural law can just be answered by referring to the rules. It's sad, but in India, most of the time, justice is done based on a sense of fairness. It should be done based on a sense of some procedure, 15 minutes per witness, how many questions can you ask, and things like that. And then I think that difference goes away. I think it's because of underinvestment in procedural rules, we try to compensate that by hiring extremely experienced people rather than building systems. And that was thought to be the way to escape the problems of the judiciary. That slowed it down, and I don't think it works in that sense. I just had some observations about the NTC. The first one is about vacancy. We did some research on, do vacancies matter, because high courts have been publishing their annual reports, which prominently has the vacancy number for around 15 years now. And we did it in 2018. Vacancy increase does not reduce pendency in any of the high courts over 15-year period. Vacancy increase does not reduce the number of cases disposed in a high court in year. And the most surprising thing we found was that increasing caseload per judge increases disposal rate in India in the high courts. So the reason why there is endemic vacancy in Indian judiciary is because the executive, I think, has figured out increasing vacancy does not affect any system, any productivity measure if you want to look at. The second point on that is there is a constant complaint from the judiciary that India has too few judges, too less judges. That is true if you looked at, and how did the judiciary come at this number? They looked at OECD population to judge ratio and then pointed out India has lower than that. The problem is a vast majority of Indians are too poor and have too little interaction with the state to need judiciary. And we did rough calculations because it's very difficult to achieve the numbers. Per case, India has 2x the number of judges that is there in the UK. And I think it was around 4x the number of judges that is there in California. So India is already the most overjudged administration we could find in the common law country. Like there was 2x the number of judges per case than UK. And this is something we cannot achieve. I think it's impossible because the kind of skill and experience which is needed to get to become a judge in a tribunal, I don't think there is enough people in the population to meet the population ratio. So your hinterland does not have that amount of skill. Your population does not have that. And we just have to use judges far more efficiently. Then that brings me to the third point of the efficiency. That if we get some independence from the executive, there will be more efficiency in the system. Statutorily, High Court registries, and Dr. Krishnan, you can back me up, are some of the most independent executive bodies in this country. Nobody questions the High Court budget. If the High Court wants to buy something, the Finance Secretary approves that. And the experience of High Court registries is not that they are fundamentally orders of magnitude better than tribunal registries. Nobody says, if I go to a Bombay High Court or Kolkata High Court, I get so much better service than litigants don't get much service. So the idea that if we make an independent executive to administer the systems, processes inside a court, we would get better is kind of belied from the trend that we see with High Court registries. If this is true that independence from executive leads to better functioning, then High Court registry should be fundamentally better than tribunal registries. And I have never done any practical legal work, but there are many people here who have gone to courts, looked at registries, and they can attest, I think, that really doesn't, it's a wash. And the point that Mr. Kumar made about integrity and efficiency, there's a very interesting paper in the 1980s by this professor called Robert Moog, and he spent months looking at courts in Uttar Pradesh, and he had a very interesting observation. He said that the frequent transfer of judges creates a situation where the lawyers practicing before the court have far more institutional memory than the courts itself or the judges itself. And that leads to an interesting situation where the court is actually controlled by the lawyers. That was his observation by looking at spending time inside the court. And as Mr. Kumar pointed out, that he has been in the court for 22 years, in ITAT for 22 years. And that's, I think, the explanation for success at ITAT. Relatively, it's known to be a better tribunal. Most courts today and tribunals, the judges are there for too short a period. And if you're there for too short a period, however powerful you are, and the bar has been there for 15, 20, there are bars where median age, practicing age inside that bar is 30 years. It's very difficult to boss over somebody who's been in that institution for 30 years, even if technically he's junior to you. So we have used transfers as an integrity mechanism in the Indian judiciary, and that has created efficiency losses. And maybe we need to do that. One last point about giving financial powers to the judiciary, which seems to be the trend in NTC to take decisions about purchases and things like that. Today, the executive takes those decisions, even for the judiciary, even in the Supreme Court or any of the lower courts. And the persons who are taking those decisions are open to far higher levels of scrutiny, because they are under CBI, CVC, under pressure from internal vigilance systems. In India, to separate the judiciary, we have provided far more protection to the judiciary than we provide to our executive. It is far more difficult to start a corruption case against a judge than it is to against an IAS officer. So now if members of the judiciary will be responsible for financial transactions, then we should start thinking about should those members also be open to the kind of scrutiny that executive officers who take such financial transactions are open to. Thank you.
Thank you. Thank you, Shubho. Essentially, you're saying filling up of vacancies, going by the work that you've done in the judiciary, does not necessarily seem to be the solution to this great person theory. Get a great person and everything will fall in place. Clearly, standard Indian approach to public administration is not the answer. 3, process manuals, attention to detail is the key to efficiency. 4th, you made a point about longer tenures, and the 5th point, which is actually your 4th point about High Court registry and competence for particular types of administrative transactions. Here, Surya knows this. We've been speaking regularly at the National Judicial Academy in Bhopal for the judges who are about to become chief justices. The J1 typically, who in the next couple of months, 5-6 months, will become CJ. We've been running a series of presentations where we've looked at budget estimates, revised estimates, and actual expenditure of the judiciary. And guess what? Across India, every state and the union, the AE is less than the RE, which is less than the BE. Now, there is some explanation that you gave us the money at the last minute we couldn't spend, but across the board for the last decade plus, the judiciary underspends the allocation that is made to it. And in our meetings, they all agree a lot of the reasons is our people do not know procurement well. They can't do civil works extremely, competently. So there is a whole capacity issue of the registry, because the administrative side of the judiciary is very often a very weak link. They are not necessarily from the best administrative capability that is possible even within government. So I think there is a whole issue there. Whether agencyfication in the form of an NTC can be a solution is, I think, still an interesting question. Now, Pratik, can I request you to come in? You've heard Surya, you've heard Mr. Kumar, you've heard Shubho. Over to you now on some of these and other issues that you've extensively written about.
Thank you, sir. I think that's a good, context setting for what I wanted to talk about, and that is about the administrative efficiency. We kind of need to divide this discussion into 2 parts. One is the issue on judicial independence, which pertains to the tribunal appointment and removal process. The other part is the administrative efficiency that Dr. Krishnan just talked about. The question is, what should be the institutional construct to achieve these objectives? Should it be the same institutional construct, or should it be different institutional constructs? Now, in the literature review that we have done across UK, US, Canada, and Australia, there are dedicated administrative support services agencies for their courts and tribunals. Now, obviously, US doesn't have tribunals, but for courts, they have separate administrative support services agencies. Now, these agencies do not get into appointment of judges or tribunal members. That's not their job. Their job is purely to provide administrative support services. And the discussion in India, and now let's come back to the discussion in India, okay? And as Surya pointed out, this actually has been happening since 1987, because the Law Commission in 1987 for the first time pointed out the need for a dedicated agency. And then L. Chandra Kumar came in after a decade. And subsequently, this idea of NTC is actually quite recent. It, to my understanding, and subject to correction by Surya and the other panelists, This idea came in Roger Matthews' case in 2018, when a concept note was provided by the court by the amicus. Now, in that concept note, the idea of NTC came in, and it was primarily focused on appointment process, appointment and removal of tribunal members process. And it was from that perspective that the amicus had suggested setting up of NTC. Now, somewhere down the line, this discussion led to the final order of the Supreme Court, where the NTC's mandate got extended to providing infrastructure services. I don't think much discussion has happened in the court as to whether this is the appropriate institutional construct, that can a body which is supposed to appoint and remove tribunal members, should they be also tasked with, as Dr. Krishnan says, procuring and tendering services? I don't think that's the way it should work. And going back to the FSAT work that we did, at that time in 2010, there was a report, by a committee chaired by Nandan Nilekani on how to get IT intensive projects done within government departments. And that committee had suggested this structure of a corporate structure, which is at arm's length from the government for doing IT intensive projects. So that's why in the FSAT report, we had suggested this structure, and this structure is also followed in, for example, in GSTN, where there's a Section 8 company that provides the administrative support services for a project like that. So we took that concept and applied it for tribunals and said that administrative, support services could be done by a company structure, which is at arm's length from the tribunal as well as from the ministry, and they will do purely administrative support services like procurement, etc. They will have nothing to do with the appointment process whatsoever. So that is my views on the administrative sides. Now, coming to what I understand is the NTC's role in tribunal appointment and removal, I think what is being talked of is a body like the PSEB, the public sector enterprise, I think, board. That body basically appoints the heads of PSUs in India. So you are essentially looking at NTC for doing the same function vis-a-vis tribunals. But that need not, I think we need to separate that discussion from the discussion on the infrastructure side, where I think there is a recent, discussion going on, not through judgments, but by speeches of some judges, where they've talked about the creation of the National Judicial Infrastructure Corporation. So I think we need to, at this point, start discussing these two separate institutions, NTC for appointment and removal of tribunal members, and the NJIC, which is the National Judicial Infrastructure Corporation, for providing the administrative support services to courts and tribunals in India. Thank you, sir. Over to you.
Thanks, Pratik. It's a useful distinction that you've drawn, separating the administrative support services, including IT, from the appointment process, and linking it with the Nandan Nilekani recommendation, the FSAT task force work that you were associated with. Clearly, for tribunal appointments, there is something like a PESB system already in place, because over a period of time, let's say you take SAT, there is a nominee of the Chief Justice, and there is a set notified set of people who constitute the search body. I think, but for the fact that we've now started revisiting qualifications and the prescriptions, each round of appointment, we come up with a new set of qualifications. There was, in practice, a PESB-like body, not constituted for all tribunals, but for each separate tribunal. But we didn't have an administrative agency to sort of support in the manner that you described. With that background, thank you, Som, for joining us virtually. As somebody who is associated with the FSAT task force, and somebody who is perhaps, and Baram would again bear me out, among the more successful tribunals in India, I think in terms of relative speed of disposal, etc., is the Securities Appellate Tribunal, with which you've had a long association. Over to you now, Som, for a quick response to all of these issues that you missed the initial presentation of Surya, but those are points that you're familiar with. You heard the other speakers. Over to you on some of these issues.
Yeah, thank you, KP. I think I just want to highlight that a lot of time does get spent, a lot of judicial time does get spent in administrative issues of running a tribunal, which is a highly avoidable state of affairs. Therefore, from an infrastructure management point of view, I think there is a clear need to deal with a sort of a body corporate, whether we form it as a company, we form it as a statutory body. There is a need for an infrastructure management entity, because what is good for one tribunal administratively is substantially good for another tribunal administratively. Now, if you leave out the judicial action, the administrative stuff, like, what is the public utilities in the tribunal? Are toilets there? Is drinking water available? Is free Wi-Fi available? Is there a breakout room for parties to meet? Is there a waiting area? Frankly, the pandemic has taught us how many of these issues, which needed to have been thought about all along, were being forced onto the agenda for future thinking. In terms of the sheer place to wait while cases are being heard. For example, now judges who are appointed are not administrative experts. It's not their job to pretend to be experts in these areas. So to the extent tribunals could be physically supported in the infrastructure side by a body corporate, by an entity, something akin to the UK model, that would be very, very important. I think I worry a little bit, KP, about any reference to appointments being fastened on to any external agency, whether it's the same vehicle that manages infrastructure or another forum that manages appointments. I think appointments is an area we should leave to the larger play of political science, larger play of how it evolves over time, because that's the surest way to ensure that what we plan to do gets grounded. So a wider discussion is in fact needed on appointments. And as you rightly pointed out, there are committees of appointments with representatives of the judiciary and the administrative ministry. Some legislation actually have it, some follow it because it's a good practice, because court judgments do it. I think it's important to even legislate how tribunal members are chosen. The current tussle, I think, is between the executive and the quasi-judicial entity. Earlier, one would hear about institutional tension between the judiciary and the executive. That tension is now between the quasi-judicial forums and the executive. So the executive is bound to be unhappy with decisions of the quasi-judicial forum, which is the tribunal. Therefore, to what extent do we insulate? Frankly, even there, dependency comes in on the administrative side. If you have a regulator whose orders are appealable every day, and that regulator is really managing the infrastructure, or providing office space, or running errands for the tribunal, I think there's a breakdown there. So I think there's a clear need to set up an infrastructure management and administrative entity. On the appointments, I would say I would leave it out, frankly, and look at a wider institutional solution on how we appoint timely members of our tribunals. I would think parking that aside is likely to get greater traction and greater success in the administration of the tribunals.
Thank you. Thanks, Som. Again, somewhat similar to Pratik, making a clear distinction between appointments and the need for an infra management body, and clearly saying that the infra management body probably is a cross-cutting in terms of applicable to tribunals, regardless of the nature of the work that the tribunal is doing in a judicial sense. And 3, executive versus quasi-judicial, all very interesting, very useful points. Now we have 25 minutes, and I think there's a reasonable amount of audience interest, as I know. So now let me throw the session open for questions. Ajay drew my attention to the fact that we have a former member of SAT, now an academic, now a director of the National Institute of Securities Market, Dr. Gopal CKG Nair, who's with us. Welcome, Gopal. I'll come to you later. There are a couple of questions here, but very soon I want to come to you to get your perspective as a member of SAT for full 5 years. And you've also been in the unique position of having been the executive for both the SEBI and the SAT. And subsequently, you became the SAT. And now you are a SEBI academic institution. So multiple perspectives. But before that, Ajay, you had a question.
I have been in innumerable of these discussions, perhaps over the last 10 years. I want to wonder, and maybe others in this room understand this better than me. Why do we not talk enough about the end objective, which is that cases should be decided correctly? I feel we talk a lot about productivity and efficiency and process engineering and practical aspects. We talk a lot about appointments, but all this is a means to an end. The game is that in a good country, more cases are decided correctly. Are we being too reticent in discussing cases being decided correctly? And would it be efficient to go more frontally about the various elements of what makes a good order? As an economist, it seems to me that it is too easy to put an accent on measures like pendency or time delay, and to work administrative steps to push those numbers. And these can come at the price of more cases being decided badly.
Better?
Yeah, thank you. So kind of in the same vein, when I've been, trying my best to push for the vacancies to be filled in NCLT for the IBC cases, the pushback is kind of the same, saying that, capacity building is lacking. And therefore, would you like me to put someone who's not capable, who doesn't get it, and then you end up with the wrong result? So is it, I think, kind of what you were saying again, that vacancy may be better than having the wrong person in the seat? So something towards capacity building. And sorry, vested interest, but I also wanted to ask you, because you were there right from the inception, that the idea was, as you mentioned, some technical capability as well, and hopefully growing with the years. So again, the length of the tenure, I think, is very important. And you will remember that the idea was that we would have specialists in bankruptcy, so that when you're hearing the IBC cases, they would be decided well and quickly, because they would get it fast. Now, at what point are we going to, and who makes the decision that we have separate benches at least for IBC and separate for Companies Act? Because frankly speaking, because we have got a lot of priority, the company cases have suffered hugely. And, there's much more delay on that score, which Som will also attest to. So that was my other point that I wanted to make. And again, completely reinforce the point that everyone's making. You may remember, Susan will definitely remember, that we had taken this up even with the FM, that the UK model works very well. Lawyers and judges are not the best guys to administer the process. It's also a waste of their judicial time. And, just to bring more clarity, there's, when you're talking about this infrastructure admin body, there's the administration day-to-day of the caseload, which can be done much better. And then there's what you all are talking about, procurement and general infra. So there are two different roles, probably done best by a separate entity, whether it's a Section 8, whether in the UK it's a government body. So we had put it out there, and I really think it's critical. And people like Som, I guess, can push that fast forward. Whoever I spoke to at the bench were pretty open to the idea.
Thanks, Bairam. Anyone else here who has a comment, question? Yeah, I will come to him. If no one else in the room, Surya, you wanted to come in, or
Yeah,
you,
I'll just respond to the idea of appointments being separated from government administration. I think there's a difference between who appoints versus a secretariat which supports that appointment process. So the judgment comes up of secretariat that supports the appointment. So we're not saying that this body should appoint. Again, that's a discussion depending on the type of the body that comes up, just trying to draw the distinction.
Thanks, Surya. Mr. Pramod Kumar, you wanted to come in?
Yeah, I had 2 points to make. First point is, as regards the appointments, one must bear in mind the fact that in the Reforms Act, which is the Tribunal Reforms Act, there is a mechanism already provided. So we are disregarding the law as it exists, and that is something like a PSEB, as you suggested, and then visualizing that everything will go to NTC. That's one aspect. The second thing I would entirely agree with Ajay when he said one of the most essential things that we have to be passionate about is the quality of justice. That's what I was referring to when I said about the institutional integrity and efficiency. And unfortunately, in the middle of all this is completely lost. Now, when I sit at the helm of the affairs, I'm more concerned about the issues which are other than judicial issues, rather than being a role model for our member colleagues and our others, and rather than giving the decisions which not only decide the case, but which have normative effect in the sense they lay down the principles. That valuable time is being lost. So I would very strongly agree with him on saying on the proposition that one of the most important things that people at the helm of affairs need to do is to be role model themselves so far as the judicial work is concerned, to pursue excellence and to simply ensure delivery of highest quality of justice.
Thank you, Mr. Pramod Kumar. Gopal, this looks like a good stage for me to invite you on the issues that are now raised, and even on the other issues that were raised earlier. Would you like to come in and give us your thoughts based on your own experience in the SAT?
Yes, definitely. Thank you very much for giving this opportunity. And I'm sorry that I got a little late in entering the room. And I'm seeing many of you after long years, except Dr. Krishnan and Som, all others. And of course, Mr. Pramod Kumar only about 6 months back. And thank you very much anyway. So I have a few observations, and as some of you know, I am not a very good believer in systems as they are practiced. So when I came to SAT, I will, of course, with your permission, I will give my observation in terms of certain anecdotes, which will tell the story of whatever we are talking in this room. Because the first statement is that substantive institutional reforms are normally discussed only in forums like this, not in the places where it need to be discussed and operationalized. So there the discussions go around, how are you doing today? How is your daughter there in the US, and all those things. And then finally come to the thing that if things are broken, why change? So the final conclusion is that often. So having said that, since I was also part of a team who happened to be a little bit lucky in addressing institutional reforms from comfort zones of commissions or conference rooms, when I came to SAT, I asked one simple question. Given the conditions of weather in India, can we have some slight changes in the dress code, which we use in Mumbai, in SAT, for instance? So the answer was again a one-liner. As long as there is a rule, let us follow it. So then I, being not normally called down by seniors, I mean, unfortunate part of my life is that I often contradict my seniors and support my juniors and other colleagues. So I told that unless we try to change the rules, how do they change? So then the question is for the ministry to change. So then I told, as far as judiciary or quasi-judicial bodies are concerned, the government will not take the initiative unless something comes from without the consultation with the judge. So if the judge itself or himself or herself moves, it will be easier. As long as there is a rule, follow it. So the tone was slightly different this time. I understood. So the first point I wanted to tell is that institutional reforms are not talked in with great deal of attention or care or anything. When FSLRC recommended certain reforms, though even it was a mixture of the opinion of a highly informed and knowledgeable group of about 10 people. So it is not that all the 10 people were equally supporting every recommendation, but it was finally arrived at as this is the basic recommendation we have come. So when we put up one view which came, I won't say when from where, is that put up this file after 7 years. And in 7 years, it is, I think in our traditional Indian belief, 7, 14, etc. has particular meaning. So it must have meaning which has gone beyond that. So at no point of time, anybody was ready to discuss such issues. I, in fact, went on pestering saying that let us have one document of law with whatever changes you want. Let us get rid of the 1835 vintage laws and let us have, like I had to do a separate battle even in changing the word temporary from the RBI legislation's preamble. Subsequently, even that was not initially agreed to, because I was told the mandate was to insert a monetary policy framework into the RBI Act, not to change its preamble. And then I had to argue with my own bosses again, not to their comfort, saying that without changing the preamble, we can't bring in a modern monetary policy framework because the Act itself is temporary for the interwar period, First World War and Second World War. There was no monetary policy. We are going to say that Section 45 ZZ, whatever it is, I don't remember, we are incorporating a modern monetary policy framework. The Act, why I told 45 ZZ is deliberately because the Act had already been amended so many times, but they did not feel it imperative that the preamble had to be changed from temporary to at least permanent. But anyway, we could do that. So I'm just giving example. So nobody discusses it seriously. Another point I want to tell is that, which is a response which Mr. Pramod Kumar told, which was not very positively addressed. Why do we need judicial members or judicial experience in a procedure like, even in a procedure like tribunal framework? So my experience tells that except when it is a box ticking type of decision, whether like in the insolvency, whether to admit a company into that insolvency framework and appoint an interim resolution professional, etc., where it's a question of only deciding whether there is actually a debt overhang and or an obligation which is pending. But in the case of many other decisions, even in the NCLT framework, when it comes to company questions of law on company matters, what happens is that you get suddenly questions about which even go into constitutional issues. Like an advocate of the caliber of, say, I don't want to name, I mean the top caliber in practicing in Mumbai and the Supreme Court or even globally, like Harish Salve, for instance, come and raise an issue that this particular thing has violated the constitutional provision in this way. But I don't think a technical member can address that issue. And without addressing that issue and just telling that it is a technical issue which you have to address, it's a question of only fact whether this fellow has violated. I think it will not give, will not be properly dispensing justice. You need to answer. Even to tell them that you shut up. I mean, you are not telling deliberately a clear point which is relevant in this context. Even that needs a lot of understanding of the constitution and the judicial process. So an understanding of the judicial process in its true spirit is necessary. From my own experience, I am telling. And that is why we need to have that experience. But overestimating that judicial process or even natural justice and all those things come from that, again, the penchant for not ready to change the institutional approach, which is built over, just like we are not ready to change our own faith. And one person tells that I am against killing of animals, but I eat non-vegetarian food. So somebody asked him that, how can you do that? They are contradictory, because I am doing it for a greater purpose, because I don't want to change the natural equilibrium given by nature. If I stop eating non-veg food, I will change the natural equilibrium. I don't want to be party to destroying the universal equilibrium. So rather I would violate a smaller principle of not killing the animal. Though I spread that message, but I am not killing. Yeah. So I can see Ajay and Dr. Krishnan are discussing about time. So the point is that beyond, unless we carry this message seriously to the people who are seriously in decision making, which Bayram has made that point actually. So we will continue to have, as Ajay said, 10 years or maybe another 50 years extensive discussions on this subject. Thank you very much.
Thanks, Gopal. I'm keeping time. We have 8 more minutes. Thank you. You drew attention to broadly what you called the inertia in the system for reforms, no great interest in reforms in the institutions that need to be discussing reforms. And I think the importance of legal constitutional background, even quote unquote for technical members, because we are talking about dispensation of justice, all very useful points. Now, in the time that we have, can I come back to each of our panelists for a quick second round? Shubho, I'll start with you. A couple of minutes maximum, quick responses.
On the issue of accuracy, I think one of the problems is what gets measured becomes the problem in India. We can measure vacancy, so vacancy seems to be a problem. And we have been trying to measure accuracy, and it's quite surprising how inaccurate Indian judicial and administrative processes are. More than 70% of the cases in SAT where the person appeals, the appellant wins. We are doing some similar study on a very smaller sample in the Calcutta High Court, and the government loses at around 80% of the time. So it creates, I think that's the point we have. We don't actually have much of a big caseload problem. We have a huge appeal problem. And that appeal problem is not unjustified with very high overturn rates. We have globally extremely high overturn rates in India, which are orders of magnitude bigger than most other countries. So that is a very interesting point. And accuracy will not come from setting up tribunals. The other thing is the deeper problem of delays in the judiciary. I think that's where we are trying to go. Why are we trying to do this? Because it seems the judiciary is slow. There are fundamental incentives to make the judiciary slow in India. So we have a procedural law which awards so low interest in winning cases that it is actually financially viable. And if you can delay a case long enough, even if you lose the case, you will make money. So in a finance conference, that's an interesting way to think about it. And in the industry, it's known as delay financing. You delay payments to finance and you can delay through the judiciary. And the rate at which government loses cases, I think it creates an incentive that the case be heard for a very long time, so that the initial officer who has taken the decision which gets overturned has probably not there when the final decision is taken. I think there's a issue there also, because as long as we have to, I think there the government's chance of saying that we will not appeal is a good strategy, that we'll have to get accuracy, and especially from the government.
Thanks, Shubho. Pratik, quick last round remarks.
Yeah, on the, I was just thinking about the reason why in India the judgments have gone into mixing the administrative aspects with the judicial issues is probably because of the Leggett report and the nomenclature that they use in UK. They use the term courts and tribunal services. Now in India, when you use services after anything, people tend to associate it with Indian administrative services or Indian police services and think of it in terms of a cadre. So if you think, if you read the judgments, it appears that the courts have thought of court and tribunal services as a cadre from where judges will be appointed. I think that is the fundamental source of confusion, is the nomenclature issue. So I think in India, it's better to call it a commission or something else other than services. I mean, which I think was the, which was probably a mistake that we made at that time by confusing the nomenclature. And on the issue of quality of orders, I think it won't be restricted to just tribunal reforms, because you can't expect only the judges to be responsible for the quality of order. What matters is also the kind of assistance they're getting from the bar, as well as appointment of research capacity within the institution. For example, there are law clerks being appointed, but today the law clerks that are appointed are freshers out of law school. Why can't law clerks be a permanent job, that you actually hire people who are experienced in the profession as support services to the judges? So again, I mean, these are issues that can be taken up by the administration wing on HR capacity of tribunals and courts. Thank you.
Thanks, Pratik. Som, quick 1 minute concluding thought.
Yeah, very quickly, I think I need to correct some misconceptions. The appeal success rate, frankly, is diametrically opposite to what was just said. In 2015, for example, SEBI's winning rate was 90%. If you look at actual reports, and we can then quibble about how you count winning rates, but the success rate is actually only about 70% of the orders get appealed. Of those that get appealed, 80% plus actually go in SEBI's favor, number one. Number two, on delay, actually, I just want to table that the need for a tribunal is to be a check and balance on the regulator. Just to give you a sample example, I've done 2 cases today. One was a transaction done in 2006, show cause notice issued in 2012, order passed in 2014, set aside and remanded in 16. A new notice after the remand issued 2.5 years later in 2018. There's no accountability for this. There is no damage, there is no cost to the regulators. In fact, delay enables the regulator to argue just on the merits as if there has been no delay. The second case was a transaction done in 2005, a show cause notice issued in 2017, with the order being passed in 2021, and then saying, look, we are very busy, there is a shortage of capacity, we don't have enough members. So I think we need to look at these things empirically. When we look at delay, frankly, I would not have a delay discussion in the context of a corporation to handle administration, because that's a discussion we will allow to have. And the real issue is about backup infrastructure for running a tribunal efficiently. It's very, very tempting to discuss judicial delay and administrative delay. That's a different discussion. It's important, it needs to be had, but not in the context of handling judicial administration and infrastructure in an efficient manner.
Thanks, Som. Shubho, do you want to clarify in exactly 5 seconds your definition of this rate, the winning rate part? I think there's some confusion. Then I'll ask Mr. Pramod Kumar if he has any concluding thoughts.
So the number of 90% comes from SEBI annual report, and SEBI used to SEBI measures as success as only cases which are, SEBI takes the denominator as total cases and numerator as cases which have been decided in its favor. It doesn't take, the denominator as the total number of cases. It takes total number of cases not remanded. So actually the vast majority of orders of SAT are remanding. Now, if it is a remand, we defined it as a loss for SEBI, because SEBI was the adjudicatory body, and if its decision goes back, when you add remand to the numerator and denominator, you get an overturn rate of 80%.
Okay.
And we have serious doubts the way SEBI presented that number in annual report. And interestingly, after a few years, when we stopped reporting that number, because it was not matching with reality at all.
Yeah. Thanks. Mr.
Sorry,
Pramod.
just a very quick one sentence. It's very historical. This is not relevant today. This is an old practice. This is an old statistical. This is not happening today. So, as I said, it's a discussion to be had, not in this context.
Yeah, thanks. Mr. Pramod Kumar, any quick concluding thoughts?
Yes, 3 quick sentences. First thing, when you mention about the government losing more cases, there are 2 factors for this. Number one, even when the issue is decided against the government keeps on raising that issue before the tribunal to keep the matter alive before the higher courts. That's one reason. There's frivolous litigation of this count, and the regulators sometimes do not take those calls, which are difficult. Second point is regarding the entire infrastructure issue. To my mind, what needs to be done is to strengthen the registry. People who are supposed to do the judicial work. So once we strengthen the judiciary, the registry, we get some public servants working there, maybe some officers from the mainstream service, that problem can be largely solved. And thirdly and final point, when you say judges alone are not responsible for the quality audits, I would strongly disagree. Judges cannot be at the mercy of the lawyers or the law clerks. I think judges need to devote more time about the judicial work. And even if they pass less number of orders, the orders have to be excellent. There cannot be any escape from pursuing excellence in this field.
Thank you. Thank you, Mr. Kumar. Surya, do you have any?
2 points, just last 2 sentences. On the quality of justice point, definitely an important discussion. But the composite issue, I think separating functions will add to quality of justice. So it is connected to the quality of justice. And on the point about how judiciary is not transparent and accountable for the budgets, and therefore giving financial independence to an NTC, which is going to be controlled by judiciary, begs the question about the structure of NTC, not about the need for it itself. Because budgetary support to tribunals need to be increased. How best to do it is separate from budgetary transparency and accountability.
Thank you. Thanks, Surya. I think we've had an excellent discussion. Very quickly, I think there is near consensus on the appointment process being separate, where the primacy of judicial and judiciary sort of related role is sort of agreed upon. 2, admin, IT, infrastructure, all of these clearly now require a solution very different from what we've done in the past. And 3, clearly, given that the executive departmental type structures don't seem to be working very well, agencyfication, but with appropriate incentives, correctly structured, is perhaps the answer. But I think on agencyfication, the work that Ajay, I and Karan have begun now tells us that in case it's going to be court and tribunals together being supported by an admin support agency, we need to be very mindful of some federalism type questions, because this can again fundamentally alter the role of the union vis-a-vis the states. So I think interesting questions, near consensus on some, a whole bunch of sort of not resolved issues. Susan, we started 4 minutes late. We are ending only 3 minutes extra. So we've saved you 1 minute. Thank you.
Thank you so much, Krishnan. But please remember, all the saving and taking has been from your next session. Very good. Then perhaps we'll balance it all out in the end. Thank you all very much. Mr. Kumar, I'm so sorry you weren't able to join us today. So goes for Som and Pratik. Hi, Mr. Nair, it's good to meet you. And Shubho is here. And thank you all very much for a very rich discussion. Surya, I hope this met your expectations in terms of what we meant to do for this. And let's chat on how we can take this stuff forward. So I'd love to say that I'm closing the session and we'll allow a 10-minute break.